I joined the parish council in 2005. My father had been on it for years. Somebody left and he asked me whether I'd join. I also ended up in a big legal battle involving a planning dispute that went all the way to the High Court. I ended up, as a result, having experience in court. In many ways, that was like a sort of a gymnasium for my legal knowledge.
You're listening to The Corruption Diaries, a series from the Tax Justice Network, where we hear from campaigners in their own words. Richard Allen is a music executive who was instrumental in closing a UK tax loophole that destroyed his business and cost the government millions in lost tax revenue. The loophole is called Low Value Consignment Relief, or LVCR. Businesses were gaining an unfair advantage on competitors by shipping products out to the Channel Islands from the UK and straight back again to avoid VAT, or VAT, a kind of sales tax. It used and abused the special status of the Channel Islands, and powerful people were fighting to maintain it. Richard was fighting to close this loophole, and in the previous episode we heard how the UK Chancellor or Finance Minister George Osborne announced in Parliament that the British government was finally going to remove LVCR from the Channel Islands.
And we're going to tackle the exploitation of low-value consignment relief that has left our high street music stores fighting a losing battle with warehouses in the Channel Islands.
That would have the effect of closing the loophole that had destroyed Richard's business. But the Channel Islands weren't going to let that tax loophole go easily.
After all this kind of celebration of the announcement of the removal of LVCR, I got an email saying we're hearing through the grapevine that the Channel Islands are going to challenge the removal of low-value consignment relief from mail-order goods. That was confirmed. And I had an email saying that you need to be involved in the hearing. And first step was to get copies of the paperwork that had been submitted by the Channel Islands.
Two barristers called Valentina Sloane and Christopher Vajda were working with Richard to fight against this LVCR Channel Islands loophole.
What Christopher Vajda asked me to do was, he said, go to the High Court, you have to go on foot, you have to go into a little office at the back, you have to request copies of all of the submissions, and you have to pay a fee and they'll give it to you. Go and do that. Went up there, went in, asked for it, came back, and I had all the submissions from the Channel Islands that they'd put in against the UK and the responses from the UK. And I read it. It was obvious that HMRC were just going to say we're removing low value consignment relief, and they weren't going to give a reason why they were doing it. In fact, even worse than that, HMRC had said, we're not going to take the view that this exemption was abused.
That mattered because it fudged responsibility and potentially any compensation claims that might be made in future. The Channel Islands threw as much mud as they could.
The Channel Islands were saying that what the UK was doing was illegal because they didn't have the right to just remove low-value consignment relief from Channel Island mail-order goods. It was basically harming them and was unfair. Christopher Vajda said to me that we had to get into court because the UK retailers had to have a voice in that hearing, because otherwise it would have just been the Channel Islands, HMRC and a judge. The people that are actually being affected by it wouldn't have had a say. I was told to email HMRC and say that we intended to intervene in the judicial review as an interested party, and would they support it. I sent that to the tax authority official, emailed her, and got an email back from the solicitor at HMRC. We will oppose your intervention and we will not let you see any of the documents. I mean, what are they playing at? You know, it's like, who could help them any more than UK retailers affected by it? And they wanted to keep us out. And I suspect the reason they wanted to keep us out because this was gradually turning into a bit of a nightmare for them. And the last thing they wanted was the history of this coming out in a courtroom. I also went to see David Gauke in his constituency office.
David Gauke was a Conservative Member of Parliament at the time.
And I said to him, look, if we're not allowed into this hearing, you could lose. And then I got a message from the civil servant that I was in contact with. We'd struck up a kind of relationship, a weird kind of enemy sort of friendliness. He said to me, it looks like the arguments are shifting in your direction. So I knew that we were on the right track then. If they weren't going to let us in, we were going to make a court application to join the hearing. Christopher Vajda made a brilliant application, and we got in. Things were moving at such a speed. I'd get phone calls, we need this, we need that. Before a court hearing, you get given all of the other side's documents. What we received was covered in redactions. It was ridiculous. There were pages and pages of redactions. I assembled, and it took me a few months leading up to the hearing in March, witness statements from all the various sectors that were affected. By that point, I knew people in the cosmetics trade, the horticultural trade, had obviously all the information from the music industry. We compiled a bundle, all the evidence, and then that was all submitted in time. In the end, HMRC could see the benefit of what I was doing. So I had an email from Valentina Sloane telling me that they'd had a meeting with HMRC's barrister and that they wanted Ravas to concentrate on providing evidence of abuse.
Ravas was the organisation Richard had founded, Retailers Against VAT Abuse Schemes. Richard was surprised that HMRC, the tax authorities, wanted help from him.
They weren't asking me directly, but I've still got the email where I'm effectively asked to do all this stuff for them. Christopher Vajda wrote a skeleton argument that would be presented by him in court. Effectively, what he said was, this is an abuse. When Christopher Vajda said to me, you need to get all this evidence together, he also said, you need to raise some money and we'll find you a solicitor. So the solicitor was David Green. He kind of relished these sorts of public interest cases. I only had to raise £20,000. And I went out to Ravas membership and said, look, we've got 2 weeks. We need to get £20,000 together. Some of the big players in terms of what I was doing, contributed money. I raised it in 2 weeks, handed it over, and that covered all our costs. And then the hearing came up. It was in the High Court. You had to get there early. And it was packed. You could barely move. I was sitting quite near the back. I took a friend with me. A friend of mine that I've known for years. He likes to do things that a lot of people haven't done. He knew nothing about this, but wanted to sit in a court hearing of great importance, just as one of those things to tick off his bucket list. He was just soaking up the atmosphere. The room was divided up with the Channel Islands government on the left-hand side of the room, and then all of the various representatives sitting in front of Lord Justice Mitting. I think I counted 13 wigs, so that's how many barristers were in court. This was a very important legal ruling in relation to European law. There was an air of importance in the room. There was the Channel Islands government, there were film crews from the Channel Islands, the Minister from Jersey was there, traders from the Channel Islands who had an interest. PricewaterhouseCoopers, the accountancy firm, were involved with Jersey and Guernsey because everybody had these swanky leather folders with PwC written on the front, and I was sitting there with a plastic file with a load of photocopies. We were really up against, the machinery of big finance at that hearing. It was a battle, really, between the Channel Islands and the UK over something that was earning them huge amounts of money. They were trying to stop it from being removed, and the UK was being forced to prevent it. And it was mind-blowing to me that all of this had come about because of me. All those people sitting in that room, Lord Justice Mitting, all the barristers, the Channel Islands, the TV, none of that would have happened if I hadn't caused such a stink going to the European Commission. When the hearing kicked off, it opened with Lord Justice Mitting giving a long talk about what mail order was. He was talking about his wine collection and how he mail ordered wine for himself, and the history of mail order going back to Victorian times. It originated in Wales. If you understood the VAT legislation and all of this, it was fascinating and really interesting. I'm sure if you knew nothing about it, you would be bored stiff. The first thing Channel Islands objected to was we were told that the UK was not going to pursue abuse arguments. They're now pursuing abuse arguments.
What they meant by abuse arguments was that the lawyers acting for the UK Tax Authority were finally arguing in court that LVCR legislation wasn't just being misunderstood, it was being intentionally misused and abused in order to dodge sales tax, lower the prices of products, and use that unfair competitive edge to make higher profits at taxpayer expense. This was Richard's experience right from the beginning. It was also the understanding of the European Commission. It looks like the HMRC lawyers were forced to acknowledge it was abusive because they had to admit in court that if LVCR wasn't removed from the Channel Island mail order trade, the UK would face EU infraction proceedings. Now, all of this went against this historic unspoken understanding between the British government and the Channel Islands, which we've mentioned before. If you start picking one tax abuse scheme, where will it end? It's the thin end of the wedge as far as the Channel Islands were concerned. Back in court, the Channel Islands legal team was not happy to see this more robust argument surface.
They were really unhappy that this whole abuse thing had come out of the blue when they'd been told in correspondence that our abuse arguments wouldn't be raised. Lord Justice Mitting congratulated Ravas for the evidence and said it was extremely clear and well laid out. There was a lot of rubbish spoken in that room. I mean, I couldn't believe some of the arguments that were being put forward. But essentially, it was a very simple point. You know, the European law says we can do this and we can do it to combat abuse, and there is abuse. When the judge made his ruling, he basically said that, look, if it says you can remove mail order goods, you can remove mail order goods from whatever you want to remove it from. Lord Justice Mitting could find nothing wrong or illegal with the measures that the UK had taken and that they were in accordance with European law, in that the UK had the right to remove the exemption. It was an unfettered power and they applied it. It caused a real sort of kerfuffle.
On the third day of the hearings, Lord Justice Mitting read out his judgment. Quote, "There is evidence from members of Ravas that this practice," he's referring to round-tripping where goods are sent to the Channel Islands and back to the UK again, "it was, and if it continues, is clearly an abusive practice."
And we realised at the end that actually we'd won, and immediately Christopher Vajda walked up to me, grabbed my hand and said, "Well done, you beat the big boys," right in front of the Jersey Minister, which was a fantastic moment. When it ended, I walked out of the High Court, and as I came out, there was a whole load of TV cameras. I immediately got stopped by Channel Islands TV, who interviewed me. After the hearing, there's a celebration over the road. Over the road from the High Court is a sort of a restaurant bar down a little side street where a lot of barristers go to either celebrate or drown their sorrows after a hearing. Everyone went over there, including HMRC staff. Everyone was really happy, congratulating each other. I even had some people from HMRC come up to me and say, "Well done." And then I wandered off from the High Court with this sort of crowd of people, and I was on my own on the train, and the whole thing felt surreal. It was almost like I had successfully caused all of this to happen, which I suppose I did. I'm sure some people will say, "Oh, that's a Pyrrhic victory." I don't really think that's an accurate description. It was more of an anticlimax in that it was very exciting, but at the end of it I thought, right, well, what good has this done me? I lost my business. I spent years on this. I lost basically my pension. What advantage is there for me in all of this? And I got quite down about that within about a couple of weeks of the court case. Then one of the people that had given me evidence, the horticultural guy, he said, "I know a lawyer who might be interested in talking to you." He put me onto a guy called Les Allen, who was a law firm called DLA Piper. And we had a long conversation, and he said, "I'll help you." Before long, we were formulating making a claim against HMRC.
You've been listening to episode 11 of the Corruption Diaries Season 2 from the Tax Justice Network, with me, Naomi Fowler, produced by Leo Schick. Delirium Records music used in this episode was courtesy of Cherry Red. If you liked a song, see the track listing in the episode notes.